Now, out of the 4,000 or so autopsy cases that you've been involved in, have you ever seen a case like this one before?
Not in the cases I've personally been involved in.
But you followed up on this case, didn't you?
Yes,
You did some research on your own.
yes,
You compared suicides by ethylene glycol to homicides by ethylene glycol.
yes.
And how many different suicides by ethylene glycol were you able to examine?
I looked at 15 of them.
And how many homicides by ethylene glycol poisoning did you examine?
Well, this one I examined directly. There were about 10 that, were public knowledge.
But you didn't get all the tox screens from the homicides.
Not all of them.
But you got tox screens from some of the homicides.
Yes,
And you got tox screens from the suicides.
yes.
What did you find in this analysis of ethylene glycol poisonings, suicide versus homicide? What did you find about, what inferences did you draw? What patterns did you see concerning the amount of ethylene glycol in a person who died by suicide versus a person who died by homicide?
Judge, I have an objection. It involves 971.23.
Take a break, folks. What statute number did you say, Mr. Perry?
I was referring to the discovery statute, 971.23. Ms. Mainland is testifying. Mr. Jambois obviously knows what she's about to testify. He's leading her to it in terms of these comparisons, this follow-up, these studies comparing suicides to homicides. And I don't believe I've been provided with that.
The information that he's asking this expert witness about?
That's right, that he, I think, plainly knows that she's done this and what her answers are going to be.
What's the state's response?
First of all, she didn't produce a report to me. She and I talked about this yesterday, and that's when she told me about it, that she'd been doing this research on her own, and she came up with this information yesterday. So it's true. Maybe I should have told them about it yesterday, but I didn't. What I'd like to do is, what's that? I looked at 971.23, or actually I'm going to look at it right now. And so let's examine my statutory obligations. We produced, first of all, they've already have her testimony from the last hearing, and of course she didn't testify about this, but they were aware of what her testimony was going to be as to cause and manner of death. And I'm going to pull up 971.23.
Under sub E, it talks about results of scientific tests, experiments, comparisons that the district attorney tends to offer in evidence at trial, and it talks about experts. So
I mean, I didn't object to the other things that, I did know about her prior testimony and the cause and manner of death opinion, didn't know about this, and I would suggest this is not a reasonable amount of time before trial. I'd ask that this be prohibited from being gone into.
Do you have something in writing as to what she was going to testify?
I'm sorry, Your Honor.
Do you have anything in writing as to what she was going to testify as to the comparison tests?
I don't have anything in writing. I don't. I don't have a report from her. I talked to her about this yesterday, and she was indicating that the average amount of ethylene glycol on board in a suicide is 2,000 micrograms per milliliter.
Because the statute then also talks about if the expert does not prepare a statement, there should be a written summary of the findings of the subject matter of the testimony. So we don't have a written statement. We don't have a written summary.
I don't, Your Honor. What I have is what she told me yesterday, and I suppose I could have told him about it yesterday, but that's when I found out about it.
For the record, we're not going there. That based on 971.23 sub E.
Okay, well, Your Honor, at this point, then I would at least like to have her produce those notes, and I will make copies of them, provide them to defense counsel, because it may be something that we'll go into on cross-examination of one of their experts, and it may be something we can go into in rebuttal after the defense has rested its case.
You're welcome to do that.
I'd ask that jury be instructed to that prior testimony as it related to her doing these comparisons be stricken and instructed to disregard it.
If I'm listening, hopefully I'm correct. We never got into the studies. She just talked about them, right?
Yes, she did.
Yeah, she talked about having.
We didn't get to the,
we didn't get
what
to
did
the-
you find, right?
I objected in time for that, but she did talk
You
about.
did a good job, Mr. Perry.
Thank you.
So you want me to just say, hey, don't, the last test transcript or the testimony, she said that they are tests that's stricken?
That she's done these comparisons, that be stricken.
And then, Mr. Jambois, you free to give the defense a summary of.
Well, I've got to look at it first. I don't know if she's got it with her. Let me. Holding up the sheet of paper.
All right.
I'll mark it as an exhibit.
And we'll mark it.
Break then?
Yeah, I was going to say, we're not going to bring back the jury and then tell them we're doing a morning break at 10:30. We'll just take our morning break, and then when they come back, I'll instruct them. And I just want to, on the record, that the defense is getting a copy of this report, so we're going to wait, and then we'll take our break.
Yes, Your Honor. And then I was hoping that I could do a brief voir dire of the witness about this information so that they will have that information, so that if I cross-examine their expert on it, they'll have that information, and they'll have that much of a report from the witness.
We'll do it after the break.
Yes, Your Honor.
Well, let's wait for the report because you marked it. I want that part of the record.
Okay, I am going to mark it. I haven't marked it yet, but I will mark it.
Brought in the courtroom by the bailiff. Reissue and a summary report that Dr. Malin provided regarding some tests that she was looking at regarding the issue of suicide versus homicide regarding the poisoning issue. You wanted to do some voir dire questions, Mr. Jambois?
Yes, Your Honor. And first, I'm going to provide you a copy so you know what we're talking about.
All right. It's been marked, correct?
Yes.
90.
All right. 90 has been marked. The defense has a copy. Correct, Mr. Perry?
That's right.
Thank you.
So, Dr. Mainland, the judge had described this as a report, but it's not actually a report, is it? It's just,
No, just some notes.
just some notes that you had obtained by looking at suicide, ethylene glycol suicides,
Yes,
ethylene glycol accidents,
yes,
and then undetermined.
correct.
Now, in the suicides that you looked at, the ranges of ethylene glycol that were found at the time of autopsy, and this is expressed in micrograms per milliliter, is that correct?
Milligrams per liter.
Milligram.
Micrograms per milliliter and milligrams per liter are the same thing,
Okay,
but you don't have to remember that.
so
So this is comparable to the units that Julie Jensen's blood, the
so-
reports
okay.
use.
So the first one is 570,
Yes,
7400,
yes,
2640,
yes,
not determined,
not detected.
not detected. Okay, 740,
Yes,
1200,
yes,
830,
yes,
less than 20,
yes,
259,
yes,
9746,
yes,
1200,
yes,
966,
yes,
4,600,
Yes,
not detected,
correct.
and 930.
Yes.
Now, where had you found these ethylene glycol suicide autopsy reports?
These are cases that came through some of the offices where I worked, Milwaukee, Tampa. I think there were a couple in there from Waukesha.
Now, when you saw some of these autopsy reports reflect not detected or less than 20, did you examine those reports to determine whether or not medical intervention had occurred?
Yes,
And had medical intervention occurred?
yes, in most of them.
In
I
the
think
cases where medical intervention had not occurred, the results were higher?
Generally speaking, yes.
And overall, in looking at the suicides, the average amount of ethylene glycol, number of milligrams per liter of ethylene glycol was 2,072,
Correct.
which is about 40 times the amount that was in Julie Jensen's blood.
Something like that.
Now, I'm not going to ask you any more about this report, but
Okay.
I am going to ask you about why one might expect to find less amount of ethylene glycol in a homicide rather than as opposed to a suicide. And you can answer that without looking at this report and referring to this report.
Okay.
You knew that before you did this report, right?
Yes.
Okay. So we're ready to proceed then, Your Honor.
Can I ask some questions about this report?
I think we should allow you to
I don't have a problem with that, Your Honor.
Dr. Mainland, did you receive these autopsy reports in these cases?
Yes.
And you have those?
I have some of them,
Not all of them?
not all of them.
I'd move for production of the ones that she has, for one.
Well, first, let's find out, where are they?
They're the ones from Milwaukee and Waukesha. I basically took notes from the cases, so I did not copy any part of the case file. I have a few from Tampa with
Do you have
me.
them here or do you have them back in Tampa?
I have a few from Tampa, I believe, with me. Hang on.
I have no objection, Your Honor, to her producing the stuff that she has. I just wanted to know what she had with her and what she didn't have with her.
Whatever she has, we can produce.
I'll wait while you look.
Yeah, the 1, 2, 3. I have 5 cases here from Tampa.
Just wait. The reporter's plugging your
Oh.
machine in.
Sorry. All right, I have 5 case reports here from Tampa, and then the rest of what I have is handwritten notes taken from case files in Milwaukee and Waukesha and Kenosha.
I'd request that, would you have a problem with us making copies of those and providing you with the originals back?
Nope.
Okay, Your Honor, I'd request that the bailiff make 2 copies. And are these going to be marked as exhibits, Counselor?
I don't
guess
know,
we'll-
they can be.
Just do 2 copies and you can make a decision later.
Okay.
And maybe we should wait for the copying until I'm done asking questions in case there's
That's
more.
how you want to proceed? Go ahead.
Do you have, are you able to look at these numbers with the records that you have and tell me where each one of these is from and the date of death?
Yes, I only have, as I said, 5 records with me. Actually, some of the notes, I think I can tell you the date of death.
Okay, did you receive these autopsy reports and toxicology results? Did you receive those electronically from people?
I probably looked at them physically.
They were mailed to you.
No. I did this a while ago while I still had access, physical access in Milwaukee.
You did this while you were working in Milwaukee?
No, but I was able to go and look at cases.
Okay, before you moved to Florida.
Yes, I believe so.
Okay. Do you have the sources for who made the determinations that these were a suicide, an accident, or undetermined?
No, I don't have the physician's name.
Do you have the reports that accompany them to support how they came to that conclusion?
No,
You just have the,
just the 5. Yeah.
for 5 of them.
Yeah.
And for those 5, you don't have the things I just asked you about.
For the 5, I have the physician's determination of cause and manner. I have the initial investigative report, and then I have the toxicology report.
Do you know which on this list, which 5?
Yeah, the 5 from Tampa. Let's see. It would be 2 of the undetermineds. Hang on. 1. And the other 3 are suicides. Wait. No. 1 is an accident, 2 are suicides, and 2 are undetermined. Those are the cases I have with me from Tampa.
Right. Which ones on this list, please?
The 2 undetermineds. Well, you see that, and they're just 2 of them. The suicides, hang on. None detected. 1 was 460 milligrams per deciliter. That's 4,600 milligrams per liter. And the last one, 930 milligrams per liter.
And the rest you have no details on with you.
I don't have any, all I have is my notes with amounts.
Which is really just reflected on this sheet.
Correct.
So no supporting documentation.
I have, well, only my notes. I've notes as to day of death and a little bit about the circumstances,
Okay,
et cetera.
So there are 21, if I can
Right.
do addition, there are 21 different things listed on here, right?
Yes.
And you can tell us, you have details about 5 of them, right?
Yeah. I mean, official details. Yes.
I thought you testified at the start. I thought when you were first explaining this, that you compared suicides, accidents, undetermined, and homicides. Was homicides
yes.
a category that you had compared?
I did, but the homicides were those are from public knowledge. I have, fewer toxicology reports.
And those aren't on this list.
No, they aren't. I don't know of any other ethylene glycol homicides either from here or down in Tampa, which is where I pulled this stuff from.
Aside from your opinion about this particular case.
Correct.
That's the only ethylene glycol homicide that you think exists, that you're aware of.
In this area, yes.
Okay, so in terms of comparing your study, comparing ethylene glycol fatalities of what's seen in a suicide and what's seen in a homicide, on the suicide list, you have 15,
Yes.
and your homicide list, which isn't on here, would be 1.
Yeah, actually there are, but I don't have amounts for most of them.
You don't know the amounts?
No.
Okay. That's all I have. I mean, I think it's, there's a separate objection just simply to relevance in terms of the
That's a different objection,
That's a different objection. It's not coming in anyway right now.
right?
I would still ask for production of those notes at this time, though.
We'll have
Your
the,
Honor, I will just say this. First of all, I think it should come in now. because now they've been provided the report. They've actually been able to cross-examine the witness about the report. They've had plenty of opportunity to discuss the report. So now the report should come in. This is normally what happens, you know, instead of evidence just being excluded, the court will give the opposing party the opportunity to voir dire the witness. And that's what they've just done. They've voir dire the witness. So now this report, her testimony about this should be admissible.
Well, let's go make the copy. Yeah, let's try to do one thing at a time here. I mean, it is Exhibit 90, right? Is that, do I got the right number?
Yes, Your Honor. As you can see, it's not a report, Your Honor. It's just a list of her notes.
I'm going to correct myself. It is what I would consider written summary. And it's pretty small.
And
I mean, I don't want to say this is extensive, but it's pretty small.
in terms of her conclusions from it and her opinion based on this list and the list of the 5 examples that I don't have yet, and all of the other limitations to this, I think the reason that statute 971-23 talks about a reasonable amount of time before trial and gives actual like deadlines for expert summaries, expert reports, is for it's logical, right? You know, we have experts in this case that we would consult with, and we would, in order to cross-examine Dr. Mainland on this, have an opportunity to find out, okay, well, what are the stats that would compare to be able to effectively cross-examine on this. And so finding out the details of her notes of, which we don't actually have at this moment yet, of really 5 cases, and then her just numbers listed for 21 different cases is not within the meaning of that statute a reasonable amount of time before trial. And so I would maintain the objection that I thought had been sustained.
Well, it had been sustained. I'm not disputing the fact that the court had sufficient grounds at the time you sustained the objection. What I'm saying is that there are 2 potential remedies. When there's been this kind of what I would call an inadvertent discovery violation. It was my fault. It wasn't Dr. Mainland's fault. And she told me about this yesterday. And when I got it, I guess I should have immediately notified defense counsel, and I just forgot to do that. But one of the other options, instead of excluding the evidence, is to allow the defense or the opposing party to voir dire the witness. And that's what's happened here. So I think now the stuff that defense counsel's raised here goes to weight, doesn't go to admissibility. And I think that it should be admitted.
Would you think it would be beneficial to the defense's expert witnesses to have this information prior to today's cross-examination?
Well, you mean so that they could then consult with the defense attorneys about it?
Correct.
Yeah, it probably would be, Your Honor.
I think it would be pretty beneficial. So it's not coming in on direct.
Thank you.
Thank you, Your Honor.
All right, bring the jury back.
Did we get those copies back yet?
I think he's still working on it. You got to slow me down sometimes.
Okay, so you're telling him not to bring back the jury.
I know. That's why you got to slow me down.
But I think, so we're not bringing in the jury yet, sir. So
We need the copies first.
Not yet.
we need the copies first, okay.
You heard.